and welcome to Arbitral Insights, a podcast series brought to you by our International Arbitration Practice lawyers here at Reed Smith. I'm Peter Rosher, Global Head of Reed Smith's International Arbitration Practice. I hope you enjoy the industry commentary, insights and anecdotes we share with you in the course of this series, wherever in the world you are. If you have any questions about any of the topics discussed, please do contact our speakers. And with that, let's get started.
Welcome back to the next episode of Arbitral Insights, in which we'll discuss the Singapore International Arbitration Center's America initiative with Kevin Nash, who is SIAC's Registrar, and Adriana Uson, who is the SIAC's Director and Head for the Americas. Let me begin by introducing myself. I'm JP Duffy. I'm an international arbitration partner based in New York that acts as both counsel and arbitrator in international arbitration seated around the world under a variety of governing laws and arbitral rules. I'm qualified in New York, England and Wales, and the DIFC courts in Dubai, where I previously practiced. I routinely represent clients in arbitrations involving India, the GCC, and East Asia. And I also had the good fortune to be listed on the SIAC arbitrator roster. As I mentioned, with me today is first Kevin Nash. Kevin is a Canadian lawyer and the SIAC's registrar. As registrar, Kevin leads the 25-member SIAC Secretariat in the provision of case management services. Over the course of the past decade, Kevin has overseen the administration of thousands of international cases under all versions of the SIAC and UNCITRAL rules. Under the Singapore International Arbitration Act 1994, Kevin is also gazetted as an appointing authority, serves as the statutory taxation authority, and is empowered to authenticate and certify awards and arbitration agreements. And last but not least is Adriana Uson. Adriana Uson is the director and head of the Americas for the SIAC, where she leads and oversees SIAC's activities in North and Latin America. In 2020, Adriana established the SIAC's first office outside of Asia in New York. She has more than a decade of experience in dispute resolution and has served as counsel on international arbitrations, as arbitrator, and as the institutional representative. Adriana first joined SIAC as counsel, during which time she administered hundreds of cases across a range of seats and governing laws. She was also involved in the drafting of the SIAC Rules 2016, SIAC Investment Arbitration Rules 2017, and the SIAC Practice Note on third-party funding. Prior to rejoining the SIAC, Adriana was a disputes lawyer at a global law firm where she advised and represented clients in international arbitrations conducted under the auspices of the SIAC, the ICSID, and the HKIAC. So as you can tell, we have a wealth of knowledge with us today, and we're really, really fortunate to have both Kevin and Adriana with us today. So with that, let's jump right in and hear from our guests. So let me just set the stage a bit by giving some of the SIAC background, and then we'll have Kevin and Adriana chime in on that a bit. So the SIAC is a not-for-profit arbitral administrator that was established in 1994 in Singapore with the objective of providing a neutral, efficient, and reliable dispute resolution institution in Asia. Kevin, can you give us a bit of background on what's gone on with the SIAC over the last 33 years, I guess?
Sure. Thanks, JP. It's great to be here. Thank you to you and to Reed Smith. I'm actually a listener to this podcast, so it's really good to be here. Giving a bit of background, 33 years of operation. SIAC started as functionally a regional center, and you can really see a very compelling growth trajectory. The real proper administration of SIAC's cases started in 2007. You can then see sets of rules in 2010, 2013, 2016, and now we're in the draft public consultation for the 7th edition of the SIAC Rules. Along the way, we went in the Queen Mary University of London White and Case survey as the second most preferred arbitral institution in the world and the most preferred in Asia. And that's really what has helped bring SIAC to global prominence, that we have this expertise in Asia, but we also have parties from all around the world.
That's great. That's it, and it has been meteoric growth. That's been really impressive to watch. The SIAC didn't exist, as you say, when I first started practicing, and now it's almost default in Asia, if not the default for most parties. And let's talk about that growth outside of Asia a bit. So while the SIAC began in Singapore and has had a lot of acceptance in Asian markets, it is not simply an Asian administrator, as you say. It's really accepted around the globe. What's really been the Singapore secret to that, Kevin?
I suppose that's the $1 million question, or when you look at some of SIAC's cases, the $7 billion or $10 billion question is, what does Singapore and SIAC have been able to do to put itself at the forefront of international arbitration? When I look at the Singapore arbitration ecosystem, I see language from decisions like the rule of law is applied without fear or favor, and there is an unequivocal judicial philosophy of the facilitation and promotion of arbitration. So it's really the entire ecosystem in Singapore that has helped build up SIAC. One of the most important moments, and Adriana and I were quite involved in this, was in the SIAC Rules 2016. Previously, it used to be a default Singapore seat of arbitration. So unless the parties otherwise agreed, if it was left silent, then it would default to a Singapore seat. But because of the popularity in the Americas, the then President Gary Bourne knew that for us to really grow as a global institution, that had to be left to the parties or to the tribunal to decide. So we've got the benefit of the Singapore ecosystem. So you have a very pro-arbitration bench. You have all of the hardware and software, modern legislation based on the UNCITRAL model law. And to a certain degree, it's based on where we are in the world. Singapore, much like New York, is an international center for finance. Singapore has that reputation of effectively being Switzerland in Southeast Asia. And maybe you just can almost encapsulate it by putting out a question that if you were a significant U.S. entity, would you be comfortable being a moving claimant against a very prominent Singapore respondent? And I think that the answer is overwhelmingly yes. Parties know that they're going to get a fair adjudication of their dispute when they come to Singapore, and certainly when they file a case at SIAC. When I look at that 25-member SIAC Secretariat, I am quite moved by the fact that we only have one Singaporean lawyer. So the rest of the Singapore SIAC Secretariat are all lawyers qualified in 13 jurisdictions around the world. So I think that gives parties the confidence.
Now, Kevin, where are some of those lawyers qualified in the Secretariat?
You know, I would have to run through the jurisdictions: India, Indonesia, United States, UK, Vietnam, Ecuador, Georgia. I feel like I'm missing a few: Canada, Malaysia. So anywhere in the world where we have our top jurisdictions, and particularly where we have those applicable laws at play, we really need to have a lawyer in the Secretariat qualified in those jurisdictions. I can think of 5 years ago, and Vietnam, a very fast-growing jurisdiction, because there's a lot of procedural nuances in that jurisdiction. Surely we need to have a Vietnamese qualified lawyer. China, we have a fair amount of Chinese language arbitration, so we need to have Chinese qualified counsel. And certainly we have so many cases involving Indian parties, so we have 3 Indian qualified lawyers in the Secretariat as well.
Well, that certainly gives a good overview of the breadth that the SIAC covers. Now, I think just to reinforce that a bit, let's talk about some of the offices that the SIAC has outside of Singapore before we get to the one in New York. So am I correct that in 2013, SIAC opened up its first overseas office in Mumbai and then Seoul? Is that right? Seoul, Korea?
Yep, that's right.
And then in 2016, SIAC opened up in Shanghai, correct?
Yep.
And then in 2017, the SIAC opened up a second office in Gujarat in India, right?
Also correct, yeah.
Now, what was the impetus for opening all those offices?
Really, it's to have a presence on the ground. So one thing that we do very well at SIAC is have a lot of analytics looking at economic indicators. We're looking at both sides of the contract. So you're seeing where, for instance, Indian parties, where those inflows and outflows of economic activity is happening. And I think that it matters to users to have a presence on the ground. I can see with the incredible amount of interest that we have in the Americas with Adriana on the ground here. So whether it's being able to call and say that you're filing a notice, I'm starting to think that notwithstanding the fact that I'm the registrar, that more American users are actually liaising with Adriana. In fact, we had a purely European dispute where they were calling Adriana to say, hey, we filed a notice. So I think that it's made a difference to have that on the ground presence. And we're looking at perhaps a few other offices that are going to be opened up in the reasonably near future. I think what's important for the Americas, and one thing that I've talked about publicly quite a bit, is potentially that move to setting up a case management office in New York.
Interesting. Well, let's talk about that New York office then. So now, Adriana, you opened up the SIAC New York office in December of 2020, correct?
Yeah, that's correct, JP.
That's some challenging timing. How did you find that process?
Oh, that was really a very challenging time. I think that was the height of the pandemic, if I wasn't mistaken, back in 2020. And so what we did was really to leverage off technology, JP. I think that's even the first time where we met. It was by Zoom. So what we've done is that we've used Zoom, we've used webinar to engage with our users. I remember that time I probably had a Zoom meeting every single day for over a year or even 2 years. And really the challenge was creating that rapport and that relationship to deepen those relationships during that time.
Yeah, that was certainly a challenging time. And I do recall meeting for the first time by Zoom. Now, Adriana, does the New York office, I think Kevin just touched on this, but does the New York office administer cases as well?
Not at the moment, JP, but we're looking into the possibility of administering cases from our New York office to provide real-time access for our users in the Americas. So that's something to watch out for.
Good. Well, we'll keep a heads up for that one. Now, what then was the impetus for opening the New York office? Like, what was its purpose when you decided to open it in December of 2020?
I think really, JP, it's because of the growing number of American parties that we have been seeing in our docket. So every single year for the last 13 years, American parties actually rank amongst our top 5 users. And there are certain years where you'll see that American parties would even rank number 1 amongst our foreign users ahead of China and India, which is saying a lot. And that is without us even having any significant engagements in the US. So it was ripe for us to open an office during that time. It just so happened that it happened right smack at the height of the pandemic. But apart from that, our relationships with the Americas or the US is quite strong. As you know, our immediate past president, Gary Bourne, is an American. Our current president, Lucy Reed, is also a New Yorker. The number 3 or sometimes 4th most appointed arbitrator by nationality with SIAC are Americans as well. We have American, counsel qualified at the Secretariat, and we've been really engaging with a lot of US law firms in SIAC. So I think with all of these, it just made sense for us to open an office in New York.
Yeah, I think it tends to give a lot of comfort to US parties when they know they have a local contact that they can reach out to. And certainly that helps with, explaining to a US party, like, yeah, this might be an international undertaking, but there's an office right here in New York. Here's Adriana, here's someone we can reach out to. Now, with that, Adriana, what does your day-to-day look like in the New York office, if you don't mind sharing that with the audience?
Oh, I mean, I wouldn't even know myself how my day would go, but typically it would be speaking with our stakeholders. So be it, at a law firm, a roundtable session with some corporates or lecturing in some universities. Mostly I'm traveling. So SIAC New York office really covers from Canada all the way to Chile, including Caribbean, Central America. So then you'll find me in different parts of Americas. And I think that's how it looks like at the moment.
Yeah, I would imagine it's probably a pretty exciting and pretty action-packed day. Well, let me just transition a bit so that people in the audience can get a bit of a sense, because we were talking about case administration and, for instance, Kevin mentioned, a purely European case in which people were reaching out to you. How many cases did SIAC administer in 2023?
Thanks, JP. I should also say, reaching back to the past question, that much of Adriana's day involves me reaching out to her, asking about U.S. arbitrators, a filing that's coming in. But moving to the question, how many cases SIAC administered? So we had 663 cases in 2023. Our previous high had been more than 1,000 cases. And this is really significant when you think that we were starting from the place of 2 cases filed in 1991 when we first opened our doors. Unsurprisingly, both of those would have been ad hoc conversion cases. And you have some of these cases that might just be a few $1,000s to cases, some of the big major projects and giga projects in the many billions. From a case management standpoint, what is critical for us, the independent and neutral SIAC Secretariat, is you treat every case the same. Every case gets the same amount of care and attention. And that's what we've really tried to focus on when we've moved from a regional institution to a global institution. The idea of this accessibility, where we're still treating every case like it is the most important case on the docket. Counsel can reach out to us, certainly not ex parte, but can certainly reach out to us on matters of procedure, the same with arbitrators, and that's been really important to our growth. At any one time, we have more than 1,000 active cases, and now in most years, we're getting more than 500 cases a year, which from an international caseload standpoint really puts us at the top of the chart for arbitral institutions.
Yeah, that's quite impressive growth and impressive numbers. Now, are there particular industries that many of those cases come from, or are there particular industries that you see more cases come from? I'd just be interested to know.
JP, it really runs the gamut, and our only limitation really is arbitrability. So you could have cases arising out of contracts, treaties, investment contracts, and it's a lot of mirroring with these economic corridors. So there's certainly a lot of international trade. I can remember during the pandemic, it felt like I was becoming an expert in the sale and purchase of masks. We had lots of those cases. We get some of the big construction and engineering cases, corporate, JV, maritime and shipping. Singapore has the second largest container port in the world. So we really want to be able to administer any kind of case with any type of law applying, and increasingly in different languages of the arbitration.
Well, that's interesting. It's unsurprising, I guess, that some of the caseload would follow economic trends, and it's also unsurprising that some of the cases would just follow what goes on in Singapore generally. Now, I think you mentioned earlier some of the top users for SIAC are China, India, the US. What countries were the top 5 users in 2023?
In 2023, we had lots of cases from mainland China, Hong Kong, Americas, India. What I found very compelling in those 2023 statistics is that our 5th most frequent user was Emirati parties. And often we had Emirati parties on both sides of the contract. And it's really a hallmark of the flexibility of international arbitration. So you may have UAE parties on both sides. They may choose an onshore or offshore seat in the UAE. They may choose a Singapore seat. And then the rest of the top 10 and those users that are starting to really matter is really a balance between common law jurisdictions and civil law jurisdictions. And if you follow SIAC and if you chart SIAC, what we really try to do is give effect to both the common law tradition and the civil law tradition. What we have been seeing increasingly with U.S. parties, and in large part to the work of Adriana, is some of those real chunky disputes are coming from the Americas. When you're looking at the highest summon dispute, the mean summon dispute, the median summon dispute, we are getting some of those very significant cases from the Americas.
Well, that's really interesting. And before we move on to the Americas, I just want to hit on a couple of points. And I guess my first question is, are you seeing trends in where cases are coming from in countries? Like, for instance, you just mentioned the top 5 user being Emirati. Would that have been the case a few years ago as well, or is that a newer development?
We've seen some signs of interest from Emirati parties and in MENA generally, but it is because of the amount of work. And it's almost like you can look at some of the fastest growing economies and some of those most dynamic economies, and then you will start to see SIAC's caseload increase. And as I mentioned earlier, what's important for us is to be able to market both sides of the contract and have the users have confidence on both sides of the contract. So a classic case involving the Americas might be a party from the US and an Indian party, a party from the US and an ASEAN party. and a party from the US and a Chinese party. What place are both of those parties going to choose? Increasingly, it's Singapore and SIAC.
Yeah, that's great to hear and unsurprising, I guess. Now, are those transactions ones that would be, for instance, just global transactions, or are they ones that might have some sort of geographic center in Asia?
One of my favorite disputes that we've had recently was a functionally domestic U.S. dispute where there were parallel court proceedings in the Pacific Northwest. I was looking for an Asian nexus. I have still yet to find it. So most of these, obviously arbitration is the preferred method to resolve cross-border disputes, but in the UAE, in the Americas, a lot of times in India, these are domestic disputes where they're choosing Singapore and SIAC. And JP, you might remember that it took some time for the Indian Supreme Court to give clarification on whether two Indian parties could choose a foreign seat. That clarification has now arrived. But even before that, because of the power of Singapore as a seat and the trust and confidence in SIAC, Indian parties were still using SIAC for functionally domestic disputes.
Yeah, it's interesting because that has been the case for many, many years before the Indian Supreme Court clarified that, as you say, almost akin to the way that some Brazilian parties use other institutions as well as the SIAC for purely Brazilian domestic disputes. It's really it's a vote of confidence in arbitration generally, I think, as well as the institution. Well, let's shift gears a bit and talk some more in a little more detail about the Americas. And Adriana, obviously, by opening an office here in New York, SIAC is targeting, the U.S. and New York in particular. But what other markets is SIAC targeting with its New York office?
JP, there's really a lot of ground to cover in terms of targets. And as a starting point, SIAC's choice to open our Americas office in New York was important. And it was very consequential and sent a message about our future direction. As all of us who live in the city would be aware, New York is the epicenter of so many things. So international arbitration and legal services, banking and finance, international trade, retailing, media and advertising, and so many others. But our users come from all over the US and across various sectors. Let's see if I can recall all of them. So over the past 5 years, we have seen parties from California, Connecticut, Delaware, Florida, Georgia, Illinois, Massachusetts, Maryland, New Hampshire, I think New Jersey, Nevada, North Carolina, Ohio. We've seen some from Texas, Virginia, and Washington, to name a few. We have been busy deepening these relationships and engaging with the local arbitration communities, establishing partnerships such as with the Silicon Valley Arbitration and Mediation Center. But our New York office really covers the whole Americas from like I said, from Canada to Chile. Latin America is especially exciting for us because of its increasing trade with Asia. Right now, we have cases coming from Belize, Brazil, Chile, Colombia, Ecuador. We also have cases from Mexico, Panama, and Uruguay, and we are eager to further expand our reach in the Americas. In fact, one of the first few things we did, JP, when we opened the Americas office was to enter into partnerships with local centers such as the Lima Chamber of Commerce, the Santiago Arbitration and Mediation Center, and the Quito Chamber of Commerce, to name a few. And we have been very active in the region since.
That's really impressive. And, people, think of the Americas and they sometimes think of a few large jurisdictions, but you're mentioning really a number of countries in the Americas that are seeing capital flows between their countries and Asia. Now, what are some of the largest Latin American markets that you're seeing activity in at the moment, other than the ones, I think you just mentioned a few, but are there others that you're seeing in particular as ones that are producing a lot of disputes?
I would say there has been an uptick in our Mexican and Brazilian caseloads. Kevin, you've seen a lot of these cases coming in. I think there are queries coming in from Ecuador as well. I think that's an area that we're quite interested. In fact, we did hire an Ecuadorian counsel in our secretariat because of that.
Impressive. How about jurisdictions like Argentina and Peru?
Yeah, actually, Argentina and Peru, one of our main targets, especially Peru. I think in Peru, they've now mandated arbitration as part of their law for public contracts. There's a lot of arbitration going on in Peru. And just before actually this podcast, I was on a webinar for the Peruvian Institute. So we are very active in Peru as well.
That's great. I would assume Colombia is an important market as well.
Yes, absolutely. Colombia, Panama, because of the Asian trade, that's also a very important market for us.
Interesting. And are you seeing disputes come out of issues involving the canal in Panama?
We actually have JP, and I should say, because Adriana has been in this role for is it 3 years?
Yeah.
In or around, there is that sort of time lag when SIAC clauses go into contracts and when you get the eventual dispute. And we have very strong indicators from many of those jurisdictions that you named that some significant entities are starting to use SIAC as their preferred dispute resolution choice. And that's one of the challenges of marketing an institution, because you actually don't want parties to go to dispute. You hope that they don't have to go to an arbitration, but that they have confidence to use SIAC arbitration clauses. So we're just as happy when we know if it's an entity from Panama, Peru, Argentina, as the case may be, that they're starting to use SIAC clauses. And whether or not that goes to a dispute, hopefully it doesn't. Maybe they're able to settle out their disputes, or because of the confidence in SIAC as an institution, the parties tend to keep to their bargains because they know if they go to arbitration, it's likely going to be very fast and very cost effective for the counterparty.
Yeah, well, that is certainly the case. I think we all always hope when we're drafting arbitration clauses that they never get invoked. But it's certainly my experience, at least, that 15 to 20% of those will end up at a certain point in time in arbitration. And so it's good to see that SIAC clauses are being written. And I know certainly clients that we have are extremely interested in that, and not simply when there's any sort of Asian nexus. It can be just about anything at this point. Well, that raises a really good question, which is, what would you say, Adriana and Kevin, have been the biggest accomplishments that SIAC has had in the Americas since opening? I mean, it's been a really challenging time, but you've obviously put SIAC on the map even more so in the Americas. So what would you see as the biggest accomplishment in the last, 3 or 4 years?
JP, I might just start and then I'll pass it over to Adriana. So the joke that I always make internally about Adriana setting up the New York office is that she effectively came here with a paperclip and ended up bartering her way into having a very well-running office. So certainly that was a challenge for Adriana, coming all the way from Singapore and being able to set up this vibrant office that is doing some really interesting things, effectively just with a paperclip and bartering her way and navigating New York City to get this office up and running. But I'll pass it over to Adriana.
Thanks, Kevin. I guess aside from what Kevin just said, I would say getting new users from new jurisdictions would be one of our biggest accomplishments, JP. Since opening the New York office in December 2020, we have gained new users from places like Argentina, with the first ever case from that jurisdiction filed just last year, and Colombia, which we spoke about. What's interesting about the case involving Colombia is that the counterparty is from Switzerland, showing the potential for cases in the Americas with no Asian nexus. We're also seeing a rising trend in cases from Panama. I think we've touched on that earlier. And more of our clauses are also making their way into contracts across Latin America. Just yesterday, we received an email from a firm in Guayaquil and Quito informing us they've included SIAC clauses across a suite of contracts. A Spanish law firm with Latin American clients recently also indicated they're trying SIAC, including us, in contracts for the first time. Peru, like I mentioned earlier, a Peruvian law firm also told us that they're currently handling a contract with an SIAC clause for the first time. So this could be SIAC's first Peruvian case if the clause is activated. There was also a prominent U.S. entertainment company that requested information on SIAC as it considers switching from U.S. arbitral centers to SIAC. And speaking on the U.S., we've seen a rise in filings since the launch of our New York office. Another notable trend is that while SIAC is often chosen when Asian parties are involved, and repeating what Kevin just said, we're now handling cases between American parties or between Americans and Europeans without any Singapore or Asian connection. And I think this trend really highlights SIAC's growing international reach and reputation.
Well, that is certainly impressive meteoric growth. And, it's a trite old song lyric, but the song lyric that if you can make it here, you can make it anywhere really is true. And you certainly have. Well, let me ask then, just a concluding question for you, Adriana, and obviously, Kevin, you should feel free to jump in as well. But where would you like to see the New York SIAC office in, say, 5 years? What would you think that looks like?
I think in the next 5 years, we see SIC becoming a major player in the arbitration landscape across the Americas. We're focused on establishing a strong presence and building solid relationships with businesses, legal professionals, and arbitration practitioners throughout North and South America.
Good. Kevin, anything you want to add there?
Maybe just that it almost goes to the mandate of an institution, is what is an institution really there for? And I think that we believe that we are there to promote the advantages of international arbitration and to really be a contributor. And that's what we've tried to be with the Americas office in New York, is to be a part of the international arbitration community. And one thing that I would say about where we want to be in 5 years or 10 years is from a case management standpoint, we just want to keep getting better and better. Arbitration is not like it was 10 years ago or 20 years ago. You have to be fast, thoughtful, precise. The case management matters, and that's what we focus on. And we're going to continue to listen to our users and try to be updating ourselves for 2024 and beyond.
Well, those are all good goals to have, and I think we'll keep our ear to the ground for future developments on things like case management and new rules. And I think I'll exercise my prerogative to reserve my right to call you guys back to discuss those things in the near future, because I think there's been such incredible growth and so many incredible developments, and I'm sure there'll be more to discuss again in the near future. But with that, I think we should conclude our discussion. And I want to thank you both. I want to thank our guests, Kevin Nash and Adriana Uson from the SIAC, for offering their invaluable insights. And I want to thank you, the listeners, for tuning in. You should feel free to reach out to Reed Smith about today's podcast with any questions you might have. I'll take the initiative and speak for both Adriana and Kevin and say you should feel free to reach out to them as well about any questions you might have. We look forward to having you tune in for future episodes in the series. So thank you again to Adriana and Kevin, and we look forward to having you back.
Thank you, JP.
Thank you.
Arbitral Insights is a Reed Smith production. Our producer is Ali McCardle. For more information about Reed Smith's global international arbitration practice, email arbitralinsights@reedsmith.com. To learn about the Reed Smith Arbitration Pricing Calculator, a first-of-its-kind mobile app that forecasts the costs of arbitration around the world, search Arbitration Pricing Calculator on reedsmith.com or download for free through the Apple and Google Play app stores. You can find our podcast on Spotify, Apple, Google Play, Stitcher, reedsmith.com, and our social media accounts at Reed Smith LLP on LinkedIn, Facebook, and Twitter. This podcast is provided for educational purposes. It does not constitute legal advice and is not intended to establish an attorney-client relationship, nor is it intended to suggest or establish standards of care applicable to particular lawyers in any given situation. Prior results do not guarantee a similar outcome. Any views, opinions, or comments made by any external guest speaker are not to be attributed to Reed Smith LLP or its individual lawyers. All rights reserved.